Hi again, everybody. I'm Rob Rosenthal with AskTheLawyers.com, and welcome to another edition of Ask the Lawyers. Today, we're going to ask questions about divorce, and specifically about dividing up property during divorce. And we're lucky because here to answer our questions is attorney Kelli Hooper of KBH Law, which serves the greater Atlanta area. Kelli, thank you so much. Welcome, and thank you for taking some time to be with us today.
Oh, thank you.
So let's start with a common question. Can one spouse end up with more than 50% of the house or property in a divorce?
Absolutely, if you have a good lawyer. So generally here in Georgia, the way that we split up assets and actually debts of a marriage too, is you split them up by equity. And so here in Georgia, we don't have a strict percentage. What you do is you look at several factors involving the marriage and how things, it's various things. It's really about 10 things. You look at the standard of living during the marriage, the earning capacities of the parties, educational, vocational skills. I mean, it's a long list of things. And then from that, you determine what's a marital asset. And once it qualifies as a marital asset, then you determine what percentage by equity each party should receive from the divorce.
How does Georgia handle it if, say, there's a house, but only one spouse's name is on the deed to the house? How is that handled?
Well, so long as the asset is classified as a marital asset, so all points of inquiry start with looking at an asset and determining whether it's marital or non-marital, okay? So once we sort of work through that rubric, we know that it's a marital asset, then it doesn't matter whether one party's name or both parties' names are on the asset. We handle that in sort of post-divorce documentation. There could be a quitclaim, there could be any sorts of things to move names around, but the naming really doesn't matter.
Well, let's talk about what qualifies as marital asset and non-marital. Is it as simple as what was brought into the marriage is non-maritable? How does that work?
Right. So any assets that the couple has prior to marriage that have not been converted into marital assets are considered non-marital or premarital assets. Generally, I like to think of it as anything post-marriage that the couple accumulates, either assets or debts, are considered part of the marriage and are subject to distribution, either for the parties coming up with an agreement on how they're going to pay that debt or how they're going to split an asset.
Now, you mentioned if it hasn't been converted. What is that process? How do things get converted to marital assets?
Well, the way it's interesting. And so it happens different ways in different families. I will say generally, let's say, for instance, it's easier to explain this with a hypothetical.
Okay.
So let's say, for instance, there is a home that one of the parties owned prior to the marriage, and it was solely titled in their name, and they had it prior to getting married. And then let's say after the wedding date, everybody's excited. They come back from the honeymoon and they move into that home. And then the couple lives there and raises their family. They have 2 kids, a dog, and a cat, all in this house that was a premarital asset, but now they are jointly paying on the mortgage on this house. They're raising the family there. If they have now commingled their marital assets for the support of that particular asset, I would make the argument that that now is a marital asset.
Is it as simple as all property, all things fit neatly into it's either marital or non-marital or marital, or is there a gray area there? And how do the courts handle that?
Well, I wouldn't say it's a gray area, but the analysis, I always start my analysis by assuming everything is a marital asset. And then you have to prove that it isn't. Because most couples, are not, do not enter into their marriage thinking that things are going to end. And so sometimes it's advantageous, especially if you have entrepreneurs, small business owners, or an inequity of income between the parties, that one spouse may have their name on everything, right? But that doesn't mean necessarily that the couple contemplated that those were going to be solely that spouse's asset. So for instance, you may have a family where dad is working, right? Dad's the moneyed spouse. He's the one getting the higher salary. So all the cars are in his name, the house is in his name, rental properties are in his name, but the marital unit is benefiting from those assets. So in that instance, everything would be a marital asset until proven otherwise.
And if there's a premarital agreement, does that change all of this, or are those also open for interpretation?
So when you have a prenup, the idea, at least here in Georgia, is that each party, if you have a good lawyer do your prenup, what happens is each party discloses all of their assets. and then they disclose all of the debts. And it's almost like a snapshot that you take right before marriage, not only the assets, but the value of all of those assets. And then you determine in the prenup how you're going to handle those assets moving forward. Either those will be declared solely your assets, or then, later on, you can convert them into a marital asset. But the idea behind it is that if both parties have assets, debts that need to be identified prior to the divorce, prior to a marriage, that's what a prenup is very good for.
You've mentioned debt several times. What do you find in your experience? Is there more of a, for lack of a better term, fight over property or debts?
Oh, it's always debt. No one wants to pay bills. I mean, I think people will, agree to share assets, but no one wants to share a debt. And I mean, I think that's common across, all socioeconomic areas,
Sure.
Regardless of gender, whether it's a same-sex couple or a heterosexual couple, no one wants to share debts.
What would be, do you have any takeaway, any advice for people that maybe they're just starting to think about the whole process of divorce, and when it comes to property and distribution, what would your couple of pieces of advice be for people?
Well, generally I tell my clients to make a spreadsheet and list every asset. And assets, again, are not just things that you currently have a note on. So it's not just your house. Mm-hmm. It's not just your car. It can be things like artwork. It can be things like, I'm stumbling here, okay. But it can be things like artwork. It can be things like points. Let's say if you have significant airline points because one or both of you works for an airline. It could be a country club membership. It could be any number of things are considered assets. So things of value from the marriage are considered assets. And on the contrary, of course, debts or anything that you have a current obligation for.
And why do a spreadsheet? Just so that once things happen, you're ahead of the game?
Well, it's so that when you come into your attorney, you can save a lot of time and money by disclosing all the assets and debts up front. Because what we really end up doing, because Georgia is an equitable division state, is you need to balance out the assets and the debts. So you look at the value on paper, how much is this couple worth? You look at how much their debt is, and then you try to figure out how to balance those two numbers. So let's say, for instance, if the couple in total is worth, let's say, $500,000, but they have $650,000 in debt. Well, now we've got to figure out a way to sort of handle those debts, figure out how to balance things out. Sometimes you can balance things out by one person keeping a significant number of the assets and the other person taking on the debt load. Other times you can balance it out by a cash lump sum, cashing out one of the assets, selling one of the assets so that you can balance everything out. When I start talking about equitable division in a divorce, it's really a math equation, right, where we're trying to balance it out so that the answer is zero. It's all balanced out on each side.
Gotcha. Kelli, thank you so much for your time and the information. I do appreciate it.
No problem.
There you go. That's going to do it for this episode of Ask the Lawyers. My guest has been Kelli Hooper, attorney at KBH Law, which serves the greater Atlanta area. Please take a second, click on the button at the bottom of the screen so you can subscribe to our YouTube channel, and you'll know when we have new episodes of Ask the Lawyers. If you're going through a divorce and you want the best information, or you're ready to choose a lawyer that lawyers choose, please visit AskTheLawyers.com. I'm Rob Rosenthal for AskTheLawyers.com.